I come now to deprivation of liberty, and there I would also try to give you just two scenarios which come from two cases, both on the European Convention but do not happen in Europe. That's an interesting thing. First, in an international armed conflict, and I think it's important in which situations this happens. In international armed conflict, in occupation of Iraq, the United Kingdom arrested Mr. Hassan for 10 days. He was not brought before a judge, and he was believed to be an insurgent, but finally, after 10 days, he was released. And the European Court on Human Rights, under its normal practice, 10 days, you cannot detain someone 10 days without a legal basis and a judicial procedure, even if it is for imperative security reasons and so on. But the court said we have to accommodate. This is what the systemic integration interpretation people like. We have to accommodate, as far as possible, the interpretation of human rights law to the applicable humanitarian law. And as under humanitarian law, internment for imperative security reasons is admissible, and as the administrative checking of the legality of the detention was given, the court considered that it was lawful. I think the result is correct, but to claim that this is an interpretation would be totally correct under the UN Covenant and under the Inter-American Convention. Under the European Convention, it's not possible because there is a closed list of admissible reasons of detention, and you cannot say, I interpret this article by putting a new reason in. And therefore, this is why, I think we have to work with the lex specialis thing. You cannot simply say it's interpreting the European Convention, because interpret is not adding something which is not in the text, but using the text. But for the UN Covenant and for the Inter-American Convention, this could certainly work. So the court said this is lawful, and humanitarian law provides the legal basis which is necessary under human rights law. The second case is the Sardar Mohammed case, which happened in a non-international armed conflict in Afghanistan. And Sardar Mohammed was also seen as an insurgent and detained by the British with all kind of checks, but no judicial control, and the United Kingdom had no legal basis in UK law or in Afghan law, because under Afghan law, United Kingdom cannot detain people in Afghanistan. And two instances of UK courts, now it has been decided by the appeal court, it will come before the Supreme Court, decided that this is a violation of the European Convention, because the law of non-international armed conflict doesn't give a legal basis, and habeas corpus prevails because there is no procedure under the law of non-international armed conflict. So the questions are now on deprivation of liberty, detention. What are the differences in which situations concerning legal basis, admissible reasons, necessary procedures to check legality, of what kind of persons in international armed conflict, in non-international armed conflict, and how to reconcile these two.
On the Mohammed case, my understanding of the Mohammed case was that the court found that there was no legal basis because there wasn't a specific authorization to detain in Common Article 3 or the additional protocol, which I found problematic just because, I mean, certainly there's state practice. You know, I mean, the reason why it refers to detention procedures and you know, other incidents of detention in the additional protocol is because I think it assumes that states will detain, and the alternative seems far scarier. If detention is not a possibility, you know, it begs the question of what is possible. Is Is it only lethal action, or does it assume that only law enforcement action would be possible when you capture someone rather than kill them?
Can I ask why you say it's not a possibility? If the court was saying it is a possibility, you just need to legislate for it.
Right, but I think that probably the state took the position that, well, by acceding to this treaty, the assumption behind the treaty was that detention was authorized because states had been doing it. It provided for detention procedures, so states were authorized to do it without a specific positive provision for it.
Well, I'm sure Marco is going to have a lot to say about that in a couple of minutes. Can I ask you, when you're thinking about all of these issues, to consider also armed groups, particularly if we're talking about non-international armed conflict and these questions, and what are the implications of what you're saying for non-international armed conflicts in that context? Any more comments on the legal basis or the reasons for detention?
And a limit, I guess, to the ICHR, because these two, logically, Mohammed will end up in ICHR, and I think from the procedural perspective, how the court will look in interpreting under Article 5, and I think it will have a different conclusion than Hassan case, because basically we are using habeas corpus as a human rights procedure to actually interpret IHL. It's fascinating, as Professor Sassoli would like to say, but at the end of the day, I think due very specifically that the legal basis is not present in NIAC in Common Article 3 and Additional Protocol 2, we will find hypothetically, I think the court will find a violation. And that's very interesting from the perspective that this will be a judgment from a court looking at detention and legal basis in IAC and NIAC, and we will have two cases. But I think what's also to pick in mind is that we are using actually the human rights procedure to look at it.
Yes, and it's worth pointing out that in the Hassan case, they kind of signaled already that this is what's going to happen when they made the comment about derogation and said, in an international armed conflict. And so they seem to be saying that they would do something different in a non-international armed conflict. I mean, we'll wait and see, but it looks like they left it open to reach, as you say, potentially a different decision, a different approach in NIAC. Gus, you?
Yeah, I mean, I just want to sort of cover ground that you've actually mentioned already to this point, but the issue at the end of the day really is not, because I think some people read into it that there must be an authorization, but if it doesn't regulate or provide for authorization for detention during NIAC, the fact remains that that authorization can come from elsewhere, and that's the factual question. So if there is municipal legislation, for example, that provides for that detention, then there is a legal basis for detention. But the point is that IHL in itself, certainly from a NIAC perspective, does not provide that legal authorization. And I think it's a very subtle thing, but people miss it, I think, in the debate. And I do think in Hassan, I mean, the language the court employed was very problematic in that dynamic between IHL and IHRL in that context. So.
Thanks. Marco?
Just on the customary law argument, it would be a good argument, and probably the European Court on Human Rights would accept customary law as a basis, but there is not sufficient practice and opinio juris. Most states confronted to non-international armed conflict have domestic legislation. Sri Lanka, Pakistan, and so on. They have domestic legislation allowing detention. And second, you could say yes, but in extraterritorial non-international armed conflict, there is state practice. Most states in Afghanistan did not detain more than 96 hours. And therefore, most states apparently thought that as they don't have a legal basis, they cannot detain people. And those who detained, again, I fully agree, they could create a legal basis either through domestic law or international law. They could have a treaty with Afghanistan which allows them to detain. No problem. I think that in international armed conflict for prisoners of war, all the 3 points are clear in IHL and therefore satisfy the human rights requirements. For civilians who are prosecuted anyway, the rules on IHL and humanitarian law are the same. For internment, you can have a doubt whether Article 78 of Convention number 4 is actually a legal basis to intern, or whether you have an occupying power has in addition to legislate. and imperative security reasons are the admissible reasons, and there must be an administrative procedure and an administrative appeal, which doesn't satisfy the law, human rights law, but the Inter-American Commission in the court case has accepted this. I think the real test is in non-international armed conflict, and there, the simple fact that internment, wounding, destruction of nature is mentioned in a treaty does not authorize to do this. Sorry, I don't understand this argument to say internment is mentioned and therefore it's authorized. Because you need an authorization. It's simply regulated, which doesn't mean authorized. And simply, I don't think a human rights body will ever accept that a hard law rule of human rights like habeas corpus will be derogated from or accommodated to or be displaced by a lex specialis, which is not hard law, but which is either drawn by analogy. And sorry, I mean, imagine a Geneva policeman arrests you and you ask, what is your basis? And he says, you know, I arrest you by analogy with another legislation. I don't think you accept that, and I don't think any human rights judge will accept it, while it would be good if we had specific rules on that, but states don't want them, because the ICRC suggests rules on detention, and the ICRC suggested to have a treaty on this, if I understand correctly, and states absolutely don't want it. Okay, if you don't want it, what you get is human rights law. Sorry for that. You could have it, because that would be accepted if there was a specific treaty which was giving these guarantees.
Just perhaps two sentences on ICRC, since that has been touched upon. Effectively, we are among those that actually consider, especially in a non-international armed conflict, that indeed there is an implied power to conduct internment. But in essence, we also say, and this is very important to package always, that IHL, as it stands, it does not, the issue does not stop there. So you need then to have grounds and procedures, and precisely that is lacking. I think nobody doubts that. So in essence, this is the reason why we are currently leading a process on strengthening legal protection for persons deprived, for victims of armed conflicts, and one of the components of this process is especially on detention in non-international armed conflicts, and this is one of the areas that is being addressed. Indeed, we would have considered it desirable if there had been an appetite at this stage for a new treaty. Politically, that does not seem to be the case. So what we are proposing, and this is the next international conference of the Red Cross and Red Crescent next December, will be a decisive stepping stone in this regard, whether the ICRC will be given a mandate to lead a further process that will eventually might lead to an outcome document or documents of a non-legally binding nature, but nonetheless of a normative character. So I just wanted to flag that. And in relation to international armed conflicts, here we are of the view that there is no need for further domestic legislation. So IHL on international armed conflicts is already sufficiently precise in terms of grounds and procedures for POWs and civilian internees. So I just wanted to complement.
Also, Article 78 explicitly said that the occupying power must legislate for the procedures. But okay.
And of course, what we didn't touch was armed groups, and you can take that away with you to think about in terms of how would this solve the issue with regard to the grounds for detention and basis for detention by armed groups.